Good evening, friends. In the series, the third part of IIC India International Center and this of India Conversations with Media, we have today Dr. Jagdeep S. Chhokar to speak on political economy and on elections. And I'll request our President, Mr. Rakesh, to come on the dais. बाद में आप नीचे आ जाए अभी तो आइए let me introduce Dr. Jagdeep S. Chhokar to you. He was a professor, teacher, trainer, researcher and advisor of management and organizational behavior at the IIM Ahmedabad from 1985 till November 2006. He is also a citizen activist for improving democracy and governance in the country, a bird watcher and conservationist, and a trained lawyer and a concerned citizen. Before becoming a professor, he was an engineer manager with the Indian Railways and worked as an international marketing manager for 4 years. He is one of the founding members of the Association for Democratic Reforms, IIC, and has been working on electoral and political reforms for over 20 years. He has taught in several countries, including Australia, France, Japan, and the US, in policy. He is a media person, broadcaster, documentary filmmaker, and activist. And most importantly, he is also a founder and head of Citizens First Television, New Delhi, which has been in existence since 1981. And has convened voluntary civil society initiatives in the 1990s, which continue to work even today, and has made several foreign visits with prime ministers and presidents. His keen interest lies in the Africa continent. And before we begin, I'll request our President, Mr. Rakesh, to welcome our guest speaker and say a few words so that then we begin this.
Thank you, Jagdeep, Prof और तमाम जो जितने लोग हैं और आज जो हमारी इस सभा को मॉडरेट कर रहे हैं हमारे बहुत सीनियर साथी हैं मित्र हैं आप सब लोग जगदीप चौकर साहब के नाम से परिचित हैं और जगदीप चौकर साहब को मैं इसलिए उनको ट्रैक करता था मुलाकात मेरी ईमानदारी से आधी हुई उनको ट्रैक इसलिए करता था कि मैं इलेक्शन कमीशन टीएन सेशन साहब के टाइम पे कवर करता था और वो चूँकि उस समय तो जॉब पे थे प्रोफेसर थे वो तो मैं उनको ट्रैक करता था फिर आई वाज वेरी इम्प्रेस्ड विद दिस डीप नॉलेज अबाउट द इलेक्शन सिस्टम एंड इलेक्शन रिफॉर्म इन द कंट्री एंड ही वाज हैविंग such a grassroots study. He was such a down-to-earth personality that he is an asset for this country, what I believe long back. So मैं ये मानता हूँ कि इनका जो नॉलेज है इलेक्शन रिफॉर्म्स जिसकी आज सबसे बड़ी जरूरत है एंड ये जो डेमोक्रेसी जो हमारी जो डेमोक्रेटिक सिस्टम है जो पार्लियामेंट्री सिस्टम है जो हमारी विधायिका है जो स्टेट असेंबली के जो इलेक्शन हो रहे हैं इन तमाम चीज़ों में जो भी डिसऑर्डर्स हमको दिख रहे हैं वो इलेक्शन रिफॉर्म्स की केवल भाषण वाली होती है वो जगदीप जी भी देख रहे हैं यहाँ ये भी भाषण होता है कि पूरे देश के एक साथ चुनाव कराने चाहिए एक साथ स्टेट असेंबली यूनियन टेरिटरीज एंड लोकसभा असेंबलीज एंड लोकसभा पार्लियामेंट्री एंड असेंबलीज एंड यूटी सब एक हमने वो तमाशा देखा अभी 15 दिन पहले कि दो छोटी छोटी स्टेट्स हिमाचल प्रदेश गुजरात उस गुजरात और हिमाचल प्रदेश में आपकी इतना बड़ा इलेक्शन कमीशन एक साथ इलेक्शन नहीं करा पा रहा और आप आज से 14 साल पहले 6 साल पहले 8 साल पहले वन नेशन वन इलेक्शन वन राष्ट्र वन रिलीजन ये सब चीजें डिस्कस चल रही तो व्हाट इज हैपनिंग एट द ग्रास रूट लेवल और what is happening in the real और जो भाषण हो रहे हैं, जो मैनिफेस्टो बोल रहा है, वो इतना उसमें विरोधाभास है, कंट्रडिक्शंस है कि ये डेमोक्रेसी के लिए बहुत बड़ा खतरा है, इस तरह की चीजें। और दूसरा, इलेक्शन बॉन्ड्स, जिस तरह से कुछ लोगों को, सिंगल पार्टी को टोटल इलेक्शन बॉन्ड, इलेक्टोरल बॉन्ड्स बेचे गए या दिया गया, उसका कोई हिसाब नहीं है, कुछ आता नहीं, पता नहीं। तो देश में जब ये जो मनी पावर का जो इन्वॉल्वमेंट है, तो वो हम लोगों का जो डेमोक्रेसी उससे और ज्यादा खतरे में है। पहले तो हम बोलते थे कि कॉर्पोरेटाइजेशन ऑफ इलेक्शन सिस्टम हो गया, हम बोलते थे क्रिमिनलाइजेशन ऑफ इलेक्शन सिस्टम हो गया। और हम लोगों ने जो यहाँ बैठे हुए हैं, ये देख लिया है कि क्रिमिनलाइजेशन ऑफ इलेक्शन सिस्टम नहीं हुआ है, criminals have virtually taken over the command. And at the same time, when we are talking the corporatization of the election, that is, अब वो आधा सत्य, अर्ध सत्य है। अब corporatization ने कंट्रोल कर दिया गुजरात एक एग्जाम्पल, और बाकी जगह भी जो इलेक्शंस की जो पूरी प्रोसेस है, उसमें प्राइवेट कॉर्पोरेट्स को हिस्सेदारी, पार्टिसिपेशन इन द प्रोसेस ऑफ इलेक्शंस, दैट इज अनदर डेंजर फॉर डेमोक्रेसी। मैं जगदीप छोकर साहब से क्षमा चाहूँगा कि मैंने उनको बहुत उनके बारे में बहुत ज़्यादा मैंने पढ़ा और उनके बारे में उनके आर्टिकल पढ़े, तो मैं बहुत ज़्यादा अपना टाइम नहीं लूँगा। मैं चाहूँगा कि दोनों के बीच में जो हमारे मित्र हैं और उनके बीच में, दोनों के बीच में हम ज़्यादा बाधा न बने, और हम चाहेंगे कि दोनों बातचीत करना शुरू करें। बहुत धन्यवाद, थैंक यू वेरी मच।
Thank you, Vinay and Chhokar. So we start our conversation. This is just a warm-up question before we get into the political economy of Indian elections. I wanted to ask Jagdeep ji, how is it that all the founders of the Association for Democratic Reforms are Ahmedabad based? You know, I mean, can you imagine 1999 in Ahmedabad? You know how important it has become now. So how is it that an IIM plays a big role in this? So
well, thank you for inviting me here. Why Ahmedabad plays a role in this is actually totally coincidental. There is no big plan, there is no big secret. It is just that one of my colleagues who was much younger, who was much younger and who was still younger because I also grew older, he got very annoyed around 1998 that people who had criminal cases against them were contesting elections and getting elected. If you remember, those of you who are old enough to remember that in 1998, there was a fair amount of coverage on this issue, media coverage. And this gentleman got very upset and he said we should do something about it. Since he was a friend, he would come and talk to me and we would talk all the time. And he said we must do something. So I told him, yeah, I'm a professor, look, man. Our job is to, teach, to do research, to etc., etc. You should do that. This is not our job. But anyway, he was more persuasive than I was, so we decided to do this. While we were still working at it, the Law Commission of India produced a report which was submitted in May of 1999, which was titled Reform of the Electoral Laws. And the chairman of the Law Commission of India at that time was one Justice P.B. Jeevan Reddy. At that time, I did not even know there was something called Law Commission of India. So that was the first time I heard of it, because there were news reports in the newspapers, and I remember in the Times of India and in the Economic Times, saying that the recommendations that the Law Commission has made are absolutely useless, they are impractical, etc., etc. But what they reported about the recommendations seemed very sensible to me. And I actually wrote a piece contradicting the opinion of of the Economic Times and sent it to them for publication, which of course was not published. But this was motivation enough for me to get hold of a copy of that report. Now, this is a fact that that report has not yet been released by the Government of India officially till today. It has not even been presented to Parliament. It continues to be a state secret, but we got hold, we all live there where nothing is secret. So we got hold of a copy and we have put it on our website and we have printed it and distributed it all over. When I read this 250-page odd report, I was very kind of shocked, impressed, etc., etc. And reading this report was the turning point where I became convinced that this is something possible. So since then, I have been in it, he is also in it. 11 of us founded this Association for Democratic Reforms. 8 were professors actually working in Ahmedabad. 2 were our alumni. One was in Ahmedabad, one was in Delhi at that time. And one was a professor in the National Institute of Design in Ahmedabad. So these were the 11 founders. And the 11 founders came when we were talking about it. We said we file a PIL and the lawyer said, what is the name of your association? We said we don't have an association. That's a long story by itself. So जो 11 लोग इधर-उधर पकड़ में आए वो पकड़ लिए और उनसे साइन करवाए. That is how it came into being. And since then we've been at it for 23 years. Out of the 11 now only 3 are active. I am one of the 3. The person who was the original initiator is now in Bangalore, he is in Bangalore. The third one was in Delhi. He was at that time an economist working in this institute called eCareer. Then subsequently he joined the private sector as an economist, chief economist of a large industrial house. And today for the last few months he is the vice chancellor of the Chhokar Institute in Pune. So 3 of us are active, rest are kind of, they are either sleeping partners or they have overslept and they have fallen by the wayside. So this is how it came to be in Ahmedabad, but today, sadly, none of us is in Ahmedabad.
I think it's good for you that you're not in.
Doesn't matter. The reason I left Ahmedabad and came to Delhi, I come to Delhi also.
So today we are going to talk about the political economy of Indian elections. Now, I think the economic aspect of the elections is very critical, and you have done a huge struggle, over these 23 years. Now, keeping aside the struggle, if we can now delineate what, according to you, is the political economy of elections.
When Suhas said this is going to be the topic of this afternoon's discussion, so I said, let me find out what exactly is political economy. But to me, the expression political economy seems very strange. I mean, it is a combination of politics and economics. And politics, since I used to be an academic, politics is the only field in the social sciences or in liberal arts which calls itself a science. Psychology, sociology, they are not sciences, but political science is a science. And then if you look at what separates a science from an art, in science the cause and effect relationships are definitive. 2 and 2 make 4 and 2 molecules of hydrogen plus 1 molecule of oxygen make either water, ice or steam. No fourth thing. So if anybody believes that in political science the cause and effect relationships are very definitive, I would like to meet that person. So it is far best for being a science, but it is called political science. Economics, I am sure there will be some economists here. Economics has also been called the dismal science, etc., etc. And there are jokes about, 2 economists don't agree with each other, they have 5 opinions between themselves, etc. So political economy, I thought, was a kind of a very strange phenomenon. But then when I tried to look at the origins of political economy, I discovered that we have our own Arthashastra, which is also a kind of an original work in political economy. How political economy applies to elections obviously is that money plays a huge role in elections. And anything where money is involved, economics has a say. And obviously elections are an essential part of democratic polity, therefore political economy of elections. Now, when I thought about the political economy of elections and what we have done, in our own experience, there have been 4 separate strands of activity dealing with so-called political economy of elections. One is election expenditure. The other is, where do political parties get their money from? How do they get it? And what do they spend it on and how do they spend it? So you may call it financial transparency of political parties. The third, which perhaps has become much more prominent in the last few years, is electoral bonds, which is a great phenomenon that the the finance minister at that time, God rest his soul in peace, said in Parliament and in his budget speech, there were 2 paragraphs which were titled Transparency of Political Funding. And the same afternoon in a media interaction he said that electoral bonds are in the nature of bearer bonds. The identity of the donor will be anonymous. And 2 days after that I got a piece saying I am looking for a dictionary which tells me that anonymity and transparency are identical. I thought they were opposite of each other. So electoral bonds are this strange creature which combine transparency and anonymity in one location. The fourth is an example of how political parties, to what extent can they go to protect themselves against the law of the land. And that is, it is part of what I say FCRA, Foreign Contribution Regulation Act. 2 major political parties of the country stand guilty of violating the FCRA according to a High Court judgment. But nothing has happened to them in the last 8 years, despite all that we are trying to do. So these are 4 examples of how money or economics plays a part in elections. I can talk about any of these or all of these as the case may be, but I'll leave it to the boss.
I think we'll pick on one by one, and then we talk of ADR's thrust to curb election expenditure.
Now the strange thing is that ADR has no thrust towards curbing election expenditure.
But I mean, it's your struggle.
ADR does not either increase or decrease anything. ADR just provides information to people so that voters can make an informed choice. ADR credo is, can we assist voters to make an informed choice, not an uninformed choice, not an ill-informed choice, not a misinformed choice. Give voters information and they will decide what they want. So when it came to election expenditure, and the reason why I said we are not trying to curb election expenditure, this is a very favorite theme of mine. I am often asked even in television discussions as to who wants to control or reduce election expenditure. People who are contesting elections, they don't want to control it. You will never see a politician, except if you are seeing from the left party, they they will never say election expenditure should be controlled. As a matter of fact, there is a limit on election expenditure of a candidate contesting elections to Parliament and State Assembly. The limit, it is general belief that the Election Commission lays down that limit. And again, elected politicians believe this. But the fact is the limit is laid down by the Government of India at the recommendation of the Election Commission. So if anything, there is a clamor all the time to increase that limit. And the limit has been increased from a lowly sum of, I think, 25,000 rupees in 1951, gradually to 70 lakhs. But when all this was going on, it occurred to us that, what do people do? Do they actually spend this money? Or how much money do they spend? So every candidate is required to give an election expenditure affidavit at the end of the election, which is a sworn document where the candidate says that he or she has spent so much money under the following heads. Now, we decided, and one of the things we do is, we get hold of hard data and then work on it to figure out what is going on. So in the 2009 election, we decided to find out how much have candidates spent. So we were able to get the election expenditure affidavits of 6,753 candidates. So we actually took these 6,753 affidavits, entered that data, analyzed that data. The limit at that time was 25 lakhs. And we found that out of these 6,753 candidates, only 4 had said that they had exceeded the limit. 4 out of 6,753. 30 had said that they had spent about 90 to 95% of the limit. So 30 plus 4 is 34. If you subtract 34 from 6,753, what do you get? You get 6,719, which is 99.99 recurring percent. So 6,719 people said they spent only about 45 to 55% on oath. When the Chief Election Commissioner heard of this information, he said, why should the limit be increased? It should actually be decreased. Because 99% people spend only half the amount. Now contrast this to the clamor that the limit should be increased. So obviously, all these sworn affidavits are in line. And the former Prime Minister, Dr. Vajpayei, is on record having said, every parliamentarian begins his parliamentary career with a line about election expenditure. Now, around the same time, in I think sometime before the 2014 election, a prominent politician who became a minister and who died in a road accident, I am referring to late Gopinath Gunde. In a public meeting in Mumbai, he said, about 8 months before the 2014 election, he said he had spent 8 crores on his 2009 election. His affidavit showed 16 lakhs. And when the Election Commission sent him a notice, he said, no, that was just a statement for public consumption. By that time, the expression Chunavi Jumla was not in vogue, but I suppose that is what it was. So, election expenditure is a huge black box. And if we look at estimates of election expenditure, the first information we find is from a PTI report in 2014, where they said that the Election Commission spent 3,426 crores on the election. only the election commission, which is on the conduct of elections, and in that also expenditure towards law and order, maintenance, etc. is done by state governments. But when we come to the total expenditure, including the expenditure incurred by political parties and candidates, the only guess available is from what is called the Center for Media Studies, which I am sure all of us know. They estimated that in 2019 election, 60,000 crores was spent. Now, if you read the report of the Center for Media Studies, they say that, this is not included, this is not included, so there is not much included. So I don't know how accurate is that assessment. The other interesting thing in the elections is that if you are a candidate in the election, in the affidavits that candidates have to give about their criminal cases and all that, they also have to give their assets and liabilities. So when you contest in the election, your assets are X. If you win the election, then 5 years hence, your assets are about 10X. And if you become a minister, then your assets are 100 to 1,000X. This is data over 4 election cycles. So there is nothing like assets disproportionate to the known sources. So election expenditure is a huge black hole. There is often talk about state funding of elections. Particularly our left parties are very fond of saying that there should be state funding of elections. Now I have several qualms about state funding of elections. The first of which is that why should it be called state funding? Where does state money from? The money comes from us, people. So I have been arguing for the last 4 or 5 years that it will be called public funding of elections. And some people are taking to it, but with difficulty. And the other reason is that in our country, what is public or what is state or what is run by the government, किसी के बाप का नहीं होता. I attended election awareness rally in a slum across the Yamuna many years ago, where for the municipal elections, the candidates had been invited and they were asked to say, what will you do? And they were asked to sign affidavits on stamp paper. Of course, candidates of Congress and BJP had not come. But other 4 or 5 candidates were there. One of them said, कि हमारी नेता ने तो हमको नारा दिया है कि जो जमीन सरकारी है वो जमीन हमारी है. तो सरकारी पैसा और स्टेट फंडिंग फ्री, बिजली भी फ्री, पानी भी फ्री. Who is paying for it? Nobody knows. But when we say public funding, then we think about it. So first is that it should be called public funding. Second is that let us say we will do public funding for it. Now for doing anything like this, you need to prepare a budget. How much money should be kept aside for that purpose? How does anybody do that? Because you make an estimate, पिछले साल कितना खर्च हुआ, उसको 10%, 20% बढ़ा देते. So for doing state funding of elections, we need to know how much money was spent in the previous election. That nobody is willing to tell us. No political party, no candidate. So how do we decide how much money to set aside? So the first requirement for doing public funding of elections is transparency in election expenditure. उसके लिए कहते हैं कि ना नॉर्मल तेल होगा ना राजा. So this much. So much about the election expenditure. If there is anything else we need to talk about election expenditure, I am open to questions.
Yeah. about this, if you can talk a bit about the financial transparency in political parties. I mean, what is the kind of protocol you have in mind to put in place?
Well, first of all, there is no protocol and there was no protocol, but the RTI Act came into being in 2005. So in 2007, we filed RTI applications to CBDT, saying that can you give us copies of income tax returns of political parties. So CBDT transferred our applications to 9 different zones where they said political parties are registered. And in time we got 9 rejection of our application. So we filed 9 first appeals in those 9 cases. And in due time we got rejection of all 9 first appeals. Then we filed 9 second appeals to the Central Information Commission. That is when the action started. Not Central Election Commission, Central Information Commission. So, Central Information Commission asked political parties and so on and so forth. In one hearing, there were 10 lawyers wearing their legal outfits. By that time, I had also finished my law. I finished in 2006. So I thought I knew it all. But I was not wearing the lawyer's uniform. These guys were so thorough in their argumentation that I was struck. And 2 of them had been flown in from Chennai, senior advocates of the Madras High Court. And you can guess which parties brought them from Chennai. And here I was sitting in a bushes like this arguing, also sweating. But luckily, on April 29, 2008, the Information Commission said political parties' income tax return should be made public. So we thought we had achieved our objective. In our entire existence for 20 plus years, we have felt that we have achieved our objective many times. But soon after that, we discovered that that objective was not really worth it. So we got copies of income tax returns. And we looked at them and we found they had declared hundreds and thousands of crores of income, but had paid 0 tax. Then we studied the Income Tax Act, and my boss is sitting here. Section 13A of the Income Tax Act says that all income of political parties is 100% exempt from income. So we were back to square one. Then we read the fine print. There was a proviso to this section 13A, which said that only those parties will get the exemption who maintain their books of accounts properly and give a statement of donations of more than 20,000 rupees each to the Election Commission of India, under section 29C of the Income Tax Act. So we went to the Election Commission of India, another RTI application. Please give us copies of the statements filed by political parties under this for the last 5 years. To our great surprise, only 2 parties had filed the statements of donations. No other party had filed, but all of them were getting the exemption.
Which were the 2 parties?
Why do you want me to be like Congress and BJP? They filed. Now, when we got these statements, we thought that those parties which had not filed the statement but got exemption, this was illegal. So we prepared a PIL saying that those parties which had not filed the statement but have got the exemption should be, one, should be asked to pay income tax. B, the income tax officials who allowed the exemption without the necessary statement should be penalized. And we thought it was a open and shut case. And that was the first case when I wore a lawyer's garb and went to the Supreme Court. and I saw our petition being thrown like this by the Honorable Chief Justice. That went nowhere. But we did not give up. We then studied these statements and studied the income tax returns. We discovered that donations more than 20,000 rupees had to be declared. Less than 20,000 rupees did not have to be declared. And when we analyzed the income tax returns, we discovered that 75 to 80% of the income declared by political parties was from unknown sources. So we said, all right, we will now look for these sources. So we filed RTI applications to political parties. And all political parties returned the application saying they do not come under the RTI. There is a definition of a public authority in the Right to Information Act under Section 2F. There are 4 conditions and political parties actually satisfy all those 4. But they said they don't come under RTI. We went to the Information Commission again, saying the party should be declared as public authorities. So the CIC said, no, we can't do it just because you are saying so. Get us more data. So we then filed about 2,000 RTI applications to various government bodies. For example, there is something called Director of Estates, which allocates government buildings, land and government buildings. All these buildings on Chhokar Road, etc., rented by the Director of Estates. So we asked the Director of Estates how much rent is being paid by these people, the political parties, for the government property they are occupying. Now, can you believe the rent for a 2-acre koti, Lakian's koti, is about 550 rupees per month.
550.
Roughly. So we went to 3 real estate agencies in the market and we asked them to estimate what would be the rent of these properties. Obviously, the rent was 10 lakhs per month. So we said that 10 lakhs minus 550 is the public revenue foregone by giving political parties these buildings on this highly subsidized. They get copies of the electoral roll, 2 copies of the electoral rolls free. They get airtime on the Doordarshan. All this costs money. So we did that data collection over 2 years with 2,000 RTI applications, only for 6 national political parties, because we could not do it for all 25. So when we presented this data to the Information Commission then declared that 6 political parties are public authorities under the RTI. This they declared on June 3rd, 2013. And we again thought, now we are part of it. Then we filed RTI applications again to political parties. They refused to accept them with no reason. We went back to the CIC, saying that your decision is not being implemented. The CIC issued notices to political parties asking them to attend its hearings. They did not bother to attend. The then election to the Information Commission said, show cause notices. Show cause why action should not be taken in. When we said, all right, show cause notice, show here. Oh yes, sir. After 2 years, on March 16, 2015, the Information Commission gave a judgment by a full bench saying the order we issued in 2013 is valid, absolutely correct. It has not been contested by anybody anywhere. But these people are not following it. We do not have the wherewithal to get our decision implemented. I actually said outside, not during the hearing, I said, if you can't get your decision implemented, what will you quit? And they said the applicant or the complainant can take whatever action they want. So we went to the Supreme Court. When did we go? 19th of May 2015, we filed the Supreme Court. Government of India filed an affidavit in August 2015 saying political parties should not be under the IIC. I wrote at that time that, when a political party says it is not under RTI, I have no problem. But when the government says, which is my government, that political party should not be under RTI, I have a problem. The case is still pending. The story goes that when we filed our electoral bonds case, the Supreme Court tagged these two cases together. So the RTI case and the electoral bond cases are tagged together. They were last heard on October 14th, and we have a date of December 6th. So transparency of financial information of political parties is impossible.
So now we come to the third aspect which you mentioned is the electoral bonds. Now I believe this is according to your website, 18,779 bonds worth 10,246.2251 crores have been sold from March 2018 to July 2022. Now this must have increased now, we are in October.
The information has not come.
Much information.
The information doesn't come when the bond is sold. It comes when political parties declare how much bond they have received.
So now where are we on this?
We are
October 14th.
We are in the Supreme Court, and what has happened in the Supreme Court I can share with you a little bit. We filed the petition in 2017, soon after the thing was announced, and then there were no hearings, etc. But finally we filed an application for a stay before the 2019 election. We said that in this election, thousands of crores will change hands, and therefore they should be stayed immediately. So the Supreme Court, a 3-judge bench, held a hearing on April 12, 2019. And I am quoting from the order that was issued on April 12, 2019. And this was the Chief Justice who was heading the bench and who wrote this order. All that we would like to state for the present is that rival contentions give rise to weighty issues which have a tremendous bearing on the sanctity of the electoral processes in the country. Let me repeat. Weighty issues which have a tremendous bearing on the sanctity of the electoral process in the country. And we need a detailed hearing. The next detailed hearing was held on March 26, 2021. Weighty issues which have a tremendous bearing on the electoral process in the country. And the March 26, 2021 hearing was also perfunctory. We had filed 6 applications for urgent hearing in the meanwhile. But the last hearing was on October 14, as I said. We have a date of December 6. I don't need to go into the details of what is wrong with the electoral bonds. I am sure everybody knows. If there are any questions or doubts about that, I
Let me
will
take that up later.
Yeah.
Okay. Then the fourth aspect is the FCI, regulatory. And if two main parties are directly also.
Let me tell you. We track all this business. So the NDA government has come up with electoral bonds. The earlier UPA government had come up with electoral trusts. And it had said, Chhokar was the finance minister, it had said that an electoral trust should be formed so that the donor and the receivers are at an arm's length. So if I want to donate something to political parties, I will not give it to a party, I will give it to an electoral trust. And anybody could form an electoral trust. And the electoral trust will collect all this money from all over the place and distribute 95% of this money within that financial year to political parties. And therefore political parties will not know who has given what money. And there will be no quid pro quo. So it started. Then we discovered that there was an electoral trust called Public and Political Awareness Trust, which had given 10 crores each to both BJP and Congress. So we became, there were other trusts like, Tata Trust, Bharti Trust and all that, but the Public and Political and Public Awareness Trust was a mysterious entity. So when we looked for, as in law, it is said, piercing the corporate veil. No, you have a company. Now, behind the company is a पर्दा, असली लोग उसके पीछे होते हैं. So when you pierce the corporate veil, you discover who's behind the corporate. क्या कहते हैं पर्दे के पीछे क्या है? So when we pierce the corporate veil of the Public and Political Awareness Trust, we discovered that there were 3 companies who had formed this trust. Sesa Goa, which dealt with shipping in Goa, of course, as the name signifies. Sterlite, which I am sure all of us know about, and there was one more, Balco, aluminum company. Now these are in different industries, they are in different states. We wondered what made them come together to form one electoral trust. So we pierced the corporate veil one more time, who was behind these 3 companies, and then we discovered Vedanta Resources Limited. A company registered in the UK, owned by an Indian, Anil Agarwal. So Mr. Anil Agarwal was the person behind the Public and Political Awareness Trust through 2 ways, but the corporate entity was Vedanta, which was registered in the UK. So we decided that this was funding from a foreign source, because the real source was Vedanta Resources. And we filed a PIL in the Delhi High Court saying that these people and political parties were, and they are still barred from receiving money from foreign sources under the FCI. So we filed a PIL in the Delhi High Court saying that they are violated the FCRA and action should be taken. So the Delhi High Court heard the case, and when was it? In March 2014, the Delhi High Court issued a decision that these 2 political parties have indeed violated the FCRA, and action under the FCRA should be taken against them within 6 months of the date of the order. So we again felt that was Madhya. So before, while this was on, and they asked the Government of India and the Election Commission to take action. Election Commission wrote a letter to the Secretary, Ministry of Company Affairs, and the Ministry of Company Affairs wrote a letter to something else. How many companies have received, etc., etc. Kuch nahi mata. But 1 week before the 6 months were over, both parties filed appeals in the Supreme Court. Okay.
Both parties?
BJP and Congress, they were the only ones involved. So they filed appeals in the Supreme Court after, we kept getting date after date, and came the 2016 budget. In that budget, the Finance Ministry added a line which did not say the FCRA is amended, but which in effect meant that the FCRA is amended and the definition of a foreign source has been diluted to protect these 2 political parties. So when the next hearing came in the Supreme Court, the lawyer for BJP and the Congress said that now the FCRA has been amended and therefore this case is infructuous. Interestingly, our lawyers had noticed that in the High Court decision, the second paragraph said the following: since the writ petition drew attention to the donations made to political parties for the period up to the year 2009, we record at the outset that our concern is not with the Foreign Contribution Regulation Act 2010, which had come into force on September 26, 2010. Our discussion of the legal position would be with respect to the Foreign Contribution Regulation Act 1976. Now what is behind this is, the FCRA was first enacted in 1976 in the Indira Gandhi regime. In 2010, the Congress itself, the UPA I should say, recast the FCRA and they issued FCRA 2010, making it more stringent. And the last section in that was the FCRA 1976 is hereby repealed. Now when the government amended the FCRA, they amended the FCRA which was in force at that time, which was FCRA 2010. But this paragraph in the High Court judgment said that the relevant FCRA was not 2010 but 1976, which had not been amended. So when our lawyer pointed this out, the BJP and the Congress lawyer said that we would like to take instructions from our clients. So the Supreme Court said, all right, come tomorrow. They said, no, sir, it should take time. Give us more time. The court said, come next week. So when they came next week, both parties withdrew their appeals. And we promptly wrote to the Election Commission and the Ministry of Home Affairs, which administers the FCRA, that now there are no appeals, please take action. Things continued without anything much being done. Came the next year, but 2017. And in 2017 budget, the government amended the FCRA 1976. A law which was not in existence. It was non-est, as they say in law. It had been repealed in 2010. And by 2017, it had been dead for 7 years. I wrote and I have been saying since then that this is like conducting knee replacement surgery on a person who has been dead for 7 years. Law is dead, but we are amending the law. This is the story of the FCRA, and one of the leading spokespersons of one of these two political parties was on tape in a television discussion saying that no, this was not a real amendment, it was a technical amendment, because if it had not been done, the only option left was to prosecute these two parties. So, prosecute these two parties. So political parties think and believe that they are above the law. And they will do what they want, including changing a law which does not exist. This is the FCRA.
So we go to the Q&A, but just before that, we just spend a few minutes on, there was, it's a kind of a victory which you had on, including the background, the criminal background of candidates in filing a self-sworn affidavit. Now this was in 2002, 2003. Now, as you mentioned when we were talking earlier in the morning, that the criminal element has gone up from 25% to 43%. Yes. Yeah. So, how do you view this dichotomy? On the one hand, you have brought in these self-sworn affidavits. Earlier they were not wanting it. The political parties opposed this. So, the same way as this other things they have been opposed. But somehow you managed to do that. And then, on the other hand, the percentage of criminals has gone up from 25 to 43 in the Lok Sabha. Yeah.
Well, if you ask a politician, they will tell you that people vote for the candidates. What do you mean? We believe that people don't have a choice. Let me ask you this, that in any constituency, whether there are 5 candidates or 10 candidates or 15 candidates or 20 candidates, how many candidates have a realistic chance of getting elected? Any thoughts? 2 to 3. Thank you, sir. So what we do in our multifarious analysis that we do, we look at constituencies where 3 or more candidates have criminal cases pending against them. And we find that there are about 45 to 48% constituencies. And we call them the red alert constituencies. So 45 to 48% constituencies have 3 candidates or more with criminal cases. Now what choice does a voter have? Either I as a voter go and cast my vote for a candidate whom I know is going to lose, or I choose one of the 3. What choice does the candidate have? What choice does the voter have? Now political parties fight it tooth and nail. We have been at it for a long time, that, and even the election commission has recommended it 5-6 times, that candidates who have criminal cases pending against them, where there are 3 conditions, where the punishment is 2 years or more of rigorous imprisonment, 2, where the cases have been filed 1 year before the date of the election, and 3, where charges have been framed. Now, framing of charges is the 4th stage in our criminal jurisprudence process. You first file a complaint to the police. The police investigate that complaint, and if they think there is something worthwhile, they are register an FIR. Then they do a detailed investigation, and then they prepare a charge sheet which they present it to a court. And the 4th stage is, after looking at the charge sheet and the evidence, the court frames charges. So charges are framed after the application of a judicial mind. When very often politicians say that these are all frivolous cases. I mean, if the case is such that it reaches the 4th stage and passes the 4th stage with the application of a judicial mind, then these people should be not allowed to contest elections. But politicians don't like it, and I have to say that in the last 7 years, at least 5 times the Supreme Court has been specifically asked this, and they have not had the courage to do it. Because there is a legal principle which was used in 2002, that there is no law. So the Supreme Court cannot make law, it can only interpret law. Law can be made only by the Parliament. In 2002, this principle was brought forth and it was accepted that if there is a gap in law, it means there is no law. Number 2, the Parliament or the legislature has not had the time and whatever to fill that gap. And number 3, public interest is suffering. If these 3 conditions are satisfied, the judiciary has a right, and the actual and legal explanation is the judiciary has a right, nay, a duty, to fill that gap till such time as the legislature fills it. That is how candidates were required to give these affidavits. There was no law. Now we have been telling the Supreme Court repeatedly that why don't you follow the same precedents and say that these people will not be allowed to contest elections until the Parliament makes a law. But what judiciary was in 2002 and what it is today is different. So that is why these people continue to get elected. And so long as political parties keep giving them tickets, they will keep getting elected because the voters don't have a choice.
So we now we going to a Q&A. So yeah, just one sec. This the guy who was raising the hand much earlier. Yeah, go ahead. Can we have the mic?
Hello, sir.
Just identify yourself.
My name is Desh, and I'm a student researcher. Sir, I'm not having a question. I just wanted that if it is possible to elaborate on the intersection of expenditure, like if you can share some insights on advertisement expenditure, political parties, and if there are any rules, something around that.
So, advertisements in the, a political party also has to give an election expenditure statement, and there is a heading there called publicity. So advertising expenditure is supposed to be declared there, but the catch is all these expenditures that are declared from the day the election is announced and the day the results are declared. Now, every day in Delhi, you see at least 4 or 5 full-page ads. Jharkhand, Trichinopoli, Gujarat, wherever. All this is not election expenditure. It is. We have a petition in the High Court. We have a petition in the High Court saying that either there should be, first of all, there is a limit on the candidate's expenditure for election. There is no limit for a party's expenditure. This itself is a huge anomaly. Number one. So we have said that either there should be a limit for political parties also, or the candidate limit should also be removed. And if there is a limit for political parties, that limit should not start on the day election is announced. It should be from 1 year from the date that the election is due. And every month the party should say how much has it spent on activity which can be related to the election, including all these ads that are given. But again, nothing is done.
Yeah, go ahead.
So, my question is about a recent phenomenon that is being talked about, and I'd like your view on how this is related to election expenditure. Something, it's about freebies. Which category can it be put into? What can be seen as freebies, and why? I'm actually quite at a crossroad about whether freebies should be part of electoral expenditure or it should not be. Because there's a huge haze right now. It has come in so many forms. So.
As Moraji Desai used to say, सवाल का सवाल ही जवाब है. The answer to your question is contained in your question itself. There is so much haze. Nobody knows what is the freebie. Defining a freebie is impossible. The other thing that we have to remember, that freebies are offered by political parties, but freebies are not given by political parties. They are given by the government. So a political party, when it gets transformed into the government, its sense of responsibility should change. And at that time, it will depend on what is being offered. An air conditioner is a freebie, but free food is not a freebie. We are distributing 5 crores of grain to 80 crore people in the country. That is not a freebie. But Everything else is a freebie.
Yeah, so
So, my
that
point-
definition.
My point is, it is not something that the Supreme Court either has jurisdiction or competence. Supreme Court should not have entertained that petition. And the Supreme Court covered itself with glory when he said, oh, there is a lawyer sitting here, let us ask his opinion. And the lawyer says, give it to the Finance Commission. The Finance Commission's job is to distribute the revenues between the states and the center. What does that have to do with freebies? But this is the legislative view of our Supreme Court. Supreme Court should have said this is none of our business, this is between the people and the political party. And if I may go a little further, as I think the President was saying, that earlier we heard a discussion on simultaneous elections. We heard it for 3 years. I myself spoke in 26 seminars across the country over 3 years. Where are simultaneous elections today? This freebie is also the same. Nothing will happen. We will spend a whole lot of time, energy, print space for several years, and we will remain where we are.
Raman?
Good. You see, I'd like to come back to the electoral bonds. What I understand is that if any company wants to purchase electoral bonds which are only routed through State Bank of India, they will have to reflect it in their books of accounts. That means I will just buy a bond for 10 lakhs and show it as part of my expenditure if I am a company. Is that right? But the opaqueness, as far as I feel, comes from State Bank of India, which does not lift the veil where that bond is going to which political party. Am I right in saying so?
First of all, State Bank is not supposed to know where the bonds go. State Bank knows who has bought it. That's all. Whom has that person or company given it to? State Bank doesn't know. Number one. Number two, the political party, when it receives a bond, it is supposed to deposit it into a pre-designated bank account. Now, whether a political party receives 1 bond or 2,000 bonds, the State Bank doesn't know. The State Bank will know that this political party has got 200 crores in electoral bonds. Number one. I'm telling you what the State Bank knows and what it doesn't know. Number two, the company which buys bonds will have to give its particulars to the State Bank while buying the bond. Then it gives it to XYZ, doesn't matter. In its books of accounts, it will reflect that they bought electoral bonds worth 1,000 crores. Period. Whom did they give it to is not to be mentioned. There was a provision in the company's law that when a company gives a donation to a political party, it has to mention the amount and the name of the party. That provision has been specifically removed. Yes, the problem with the State Bank is that the State Bank is supposed to know who has bought electoral bonds. And it is not required to reveal this information to anyone unless there is a court order. But when I tell you that State Bank will not reveal it to even the finance minister, and if you believe it, then I will have to think about it. So once the State Bank knows who has bought the electoral bond, the party in power knows. And it is not about party A or B, every party. You know, you buy State Bank, you buy, and nobody buys bonds of 10 lakhs. There is only one bond of 1,000 rupees which was bought by a journalist to disclose how there is a hidden number on it, which had not been revealed. Other than there only 1 crore and above amount. So you buy 200 crores of bond for Parliament Street, which is the only branch now there. And you start driving your car towards Upper Road. At the first roundabout, you get a phone call. मैं आपका नाम भूल गया। हाँ रमन साहब क्या हाल है? हाँ जी बिल्कुल ठीक है। वो याद सुना बॉन्ड रिंग तो लाए हो? इतना ही काफी है। You would turn your car from Upper Road to
Ashok Road.
So the problem with the bond is that it has, and this was written about 2 weeks after they were announced, that they have the potential to choke the funding to all parties other than the ruling party. Which apprehension was proved right when the information of the first year came. 212 crores worth of bonds were bought and encashed. 200 crores went to one party, and the remaining went to all other parties. So that is the problem with the state. State Bank has the information which it is not supposed to reveal, but it cannot hide from everybody. Yes, sir.
Just one second. No, I just wanted to, we have this count from your website of 18,779. So the amount is also mentioned 10,000. Now उसमें से 10,240 कितने किसको गया?
It is about 65% to the ruling party and the remaining to all other parties. You see, because why did, when it was passed in the parliament, there was no serious opposition to it. I mean, some slogans were raised, but that was all right. And only CPM has filed their petition in the court, which is being heard with our petition. No other political party is actually bothered, because वो सब लोग ये सोचते हैं हमारा भी नंबर है. When we are in power, then we will look. And state governments are getting, parties which are in power in state governments do get some bonds, not that huge numbers.
Yeah, I'm Gautam. The cue from your earlier statement about the phone call and how the bond was switched over to the party. This is what we see and observe with legislators who are elected in a particular symbol. Immediately switches over, or sometimes even en masse switching over to other parties, especially to the ruling party at the center. So my question is, have you any data about how many legislatures have switched over for the last 8 years? And the question is whether this menace can be stopped by amending the anti-defection law. And if you permit me, I have another question, small question. These days also there is a certain kind of perception about the electronic voting. So during your studies about the election process, do you find any kind of discrepancies on the functioning of the electronic voting? Most of the large democracies, they don't use electronic voting. They use the ballot paper. Even we find some results different in the panchayat results, where even in UP, where the opposition party won, but in the assembly poll the results are completely reversed. When it was EVM was used. Whether any malfunctioning of EVM, or can we doubt about the functioning of the EVM? Thank you.
Now, first of all, you said that this will lead to another small question. That small question will take 3 hours. Anyway, to answer your first question about the en masse defection, this is really extremely serious, because this is a complete breach of trust of the voters. And this has the potential of voters losing faith in the democratic process. And that is the most dangerous outfall of this activity. What can be done, in my opinion, which I said when I was asked, is that, if a person who is elected on a particular symbol or a particular party decides to defect, he should be barred for the entire term. As simple as that. But nobody is going to do it, because everybody Everybody has a hand in the thing. Whether it is Shiv Sena or BJP or Akali Dal or TRS or whatever. No political party today, and I say this with all seriousness, no political party today is actually interested in the well-being of either the nation or the people. And the reason is that no political party is internally democratic. I mean, we have this great phenomenon that everybody, all of us say, India is a vibrant democracy. I also used to say it 3 years ago when I used to go out of the country, India is a vibrant democracy. And once on television I ended up saying that, India is a vibrant democracy, but the pillars which support this vibrant democracy, the political parties are not democratic. Therefore, our democracy is hollow. Whereas हमारा लोकतंत्र खोखला है, तब तक ये एंटी नेशनल वर्ड यूज में नहीं आएगा, नहीं तो मैं मारा जाता. So we cannot have a democratic polity at the top if the political parties are not democratic. And this has been said since 1999 in the Law Commission report which I read. So we can do whatever we want. Nothing is going to change unless we do some basic reform like making political parties internally demonstrably democratic by law. So that is the answer to your first question. The second question, again, it's a huge complicated stuff, but my own sense is that there are several parts to this. EVM is an electronic voting machine. In my personal opinion, there is nothing wrong with that machine. It is a standalone machine. Other countries who have started and developed their machines were interlinked, and they could be tampered with through the net and so on. Germany went back to it on a technical, legal point, not on anything wrong with the machine. The problem has become more complex with the VVPATs, voter verifiable paper audit trail. Now, when you press a button on the EVM, information goes to the VVPAT, and you see a step for 9 seconds, and then it disappears. Then VVPAT sends information to the counting unit. There is no clarity on how that information goes and what that information is. And this came to light, at least according to our understanding, in the 2019 election. Election Commission of India used to put up on its website votes counted and votes polled. And these figures were different. And they were changing from day to day. So when this was pointed out to the Election Commission, they decided to remove it from the website.
Oh.
But people had captured these screenshots. And when it was brought to their notice, they issued a press note. It was very not even cryptic, it was ridiculous. It said, the confirmed authenticated results will be available after about 3 weeks. After the declaration of result. This is absolutely ridiculous. So that is why we have a petition in the Supreme Court on this also. So it is the whole system which is to be checked, not only the EVM.
Sir, I have a सुभाष जी, थैंक यू वेरी मच. सुभाष बहुत बढ़िया. दोनों ही मैं चाहूँगा कि दोनों सुभाष जी भी बोलेंगे. The question is
इनका नाम सुभाष है. सुभाष नहीं है.
Suhas. So I have a question that the emerge हो रहा है नया डिसीज. Religious places को election platform के लिए. And there is a clear-cut rules in the election commission that we cannot use religion for politics and election purpose. And election commission not today, it is बहुत silent है हर चीज पर. It's very clear. And अभी तो पिछले कुछ सालों से और silent हो गया है. और ये जो फील हो रहा है कि ये जो हम कह रहे हैं कि करप्शन हो गया है, इलेक्ट्रल बॉन्ड का इशू है, बाकी इशू है. I think ये जो डिसीज है इस डिसीज का तो कोई एंड नहीं है। और आज के हालत में जब हर लोग इलेक्शन के हमारे जो इलेक्शन में जो नोट इस्तेमाल होता है उस पर लक्ष्मी जी का फोटो और गणेश जी का फोटो का भी फैशन चल पड़ा है पब्लिक। तो मेरा ये कहना है, what my question is that you don't think this is a very serious issue of the day, and there should be petition before the Supreme Court and the Election Commission should be made party for this purpose, that why this platform of the religious, the Badrinath, Kedarnath, and so many other places are being used for the electoral, petty electoral gains and to pollute the mind of the voters.
I would like to know what Umakant said, I think it's very important. But they add that to appeals to boycott a particular community, religion, and hate. That's taking it, escalating it further, you see. And then the courts are, I mean, there has been a Supreme Court suo moto on that, but will it be carried forward?
On the hate speech.
On the hate speech, Delhi, that
Hate
Varna
is part of
states.
it. Hate speech is also part of it.
But it is escalating it further.
Yes, yes.
I mean, you now say that boycott the community totally.
Yes.
Don't give them
Yes.
any income. You know, I mean, this is something like getting reawakening Hitler's Germany.
This is more dangerous than that of the money, you know, more dangerous.
But this has been happening for the last 20 years.
That's why I told her that it's not,
In the state where I lived before I moved to Delhi, it has been happening since 2002. Muslims, I mean, we say a particular community, we are all shy of saying Muslims are to be boycotted economically, socially, and in every way. The fact that none of you two very senior and responsible gentlemen did not use the word Muslim also says something. हम लोगों को खुल के बात करने के में डर लगने लगा था।
तो उसी के बारे में क्वेश्चन है।
एक मिनट पहले यार इसका तो जवाब दो। तो हम लोगों को खुल के बात करने में डर लगता है। एक पिटीशन हाई कोर्ट में दिल्ली में पिछले 22 साल से चल रही। एक सरदार जी है होशियारपुर में रहते हैं। He is now 88 years old. वो शिरोमणि अकाली दल के पीछे पड़े हुए। मैं उनके साथ काम करता हूँ। शिरोमणि अकाली दल ने एक कॉन्स्टिट्यूशन दिया हुआ है इलेक्शन कमीशन ऑफ इंडिया को। उसमें लिखा है वी आर ए सेक्युलर पार्टी, एनीबडी कैन ज्वाइन। एक कॉन्स्टिट्यूशन दिया हुआ है गुरुद्वारा इलेक्शन कमेटी के वी आर ए पॉलिटिकल पार्टी, ओनली सिंग्स एंड सिंग्स कैन ज्वाइन। तो इस सरदार जी ने पिटीशन डाली हुई है कि ये दोनों में से एक तो गलत है, तो शिरोमणि अकाली दल की रजिस्ट्रेशन गलत हो। वो 22 साल से लगे हैं। एक क्रिमिनल केस चल रहा है होशियारपुर में, सुखबीर सिंह बादल, ये प्रकाश सिंह बादल, ये दोनों उसमें अक्यूज हैं। चंडीगढ़ हाई कोर्ट ने उसको अपहोल्ड किया है, उसकी सुप्रीम कोर्ट में अपील पेंडिंग है बादल की तरफ से। वो बेचारा लड़ा हुआ 22 साल से, उसकी तबीयत बहुत खराब है। उसने हमारी सलाह से, मेरी सलाह से, उसने एक और थोड़े से यंगर आदमी को पटिशनर बनाया कि ये मर गया तो पटिशन की सुन ली। उसके साथ इतनी यानी अमेजिंग चीजें हुई हैं जुडिशरी हाई कोर्ट में। तो देखिए आप तो कह रहे हैं बिल्कुल सही है, लेकिन अगर सिटीजन इसके बारे में बोलेंगे नहीं और खुल के नहीं बोलेंगे तो सर कुछ नहीं हो। जुडिशरी में भी लोगों को अपनी प्रमोशन चाहिए, रिटायरमेंट के बाद किसी को गवर्नर बनना है, किसी को राज्यसभा में जाना है, वो भी तो इंसान है हमारे जैसे। तो सिटीजन्स हैव टू से दिस ओपनली एंड पब्लिकली एंड डिफाइंटली, डर के काम नहीं चलेगा।
So, do you think?
I come to you.
Yeah. Do you think? Just a corollary. Do you think we will help Sri Lanka?
Sri Lanka was we could, but not
No,
likely.
no, the public outrage. I mean,
No, not likely because we are too large and too diverse a nation. But Sri Lanka, Sri Lanka had a lot of other issues. It was just, predatory leadership. और उसमें चाइना की भी बहुत कंट्रीब्यूशन है। So we would go our own way, but maybe not too different, I hope. Yes, sir. Luka.
Sir, you already answered. How have you been allowed to exist? How have you been allowed to exist so far?
This is going live, so we better record what you said.
I was asking, how have you been allowed to exist so far? This organization.
Please ask those who have allowed us to exist. But I actually often, I am accused of speaking ill of Indian democracy. But I also say that if you look at Indian democracy, either in comparison to its neighbors, आप एंटी क्लॉकवाइज आइए, क्लॉकवाइज आइए, आप देखिए क्या हालत है हमारे सारे neighboring countries. The other is that if you compare India to all the countries which got freedom from colonial rule in the 40s and 50s, I used to say that except for a 2-year blip during emergency, but now I have to add that it is a longer blip continuing. Indian democracy has existed. And the third explanation is that an organization like ADR has existed so far. So we have existed because I don't know why we have existed, but we continue to do what we believe is right. We don't violate the law. We don't do anything, the smallest of mistakes we don't do. We take undue precautions. And when you say how come you have been allowed to exist, this question is a very serious indicator of what you are saying. Who is there to allow me to exist or allow you to exist? Is this not your country that you want to exist? Who has got this authority that you will not be allowed to exist? ये सोचने की बात है. This is the mindset that we think we are allowed to exist.
In fact, you should not be asking that question.
No, we are not allowed to exist, my dear sir. We exist because we exist because we are here.
Yes.
So nobody has the authority to allow us or disallow us. That thought is scary to me when you say this.
It was a sarcasm because today
He is an old friend. So we should not have this thought, but you're right, a lot of people do ask, and I say this, that ask the people who are allowed to, I don't know who's allowed to do this.
it's a surprise.
I know.
Yeah, please.
Has your organization, ADR, done any comparative study of these issues and concerned laws in other major democracies and how these stand in comparison with them? With political funding or defections or your auditing of the accounts of the political parties.
You see, we have not done any study. The reason we have not done any study are the following. Two. One, we are so busy doing what we are doing, we don't have time, we don't have money, we don't have resources to worry about other countries. We have got requests from other countries, but we have turned them down. Because we believe we should first set our house in order before trying to preach others' work. Number two, which is a more serious answer, I think Indian democracy has so much experience by now, and the experience is so extremely rich and varied that we don't have to learn anything from anyone. The kind of problem we have, defection, doesn't exist in mature democracy. Criminalization, people find it impossible to believe that a man with a murder case or a rape case against him is being elected. I mean, the question doesn't rise. I mean, what do you compare with what? So, the situation is extreme, and then there is a thought about what is a democracy? Is Iraq a democracy today? Is the United States really a democracy? Is UK a democracy where there have been 3 prime ministers in 2 weeks? So, what is a democracy is an issue to think about. And according to me, there is nothing like a perfect democracy. This is a continuum from zero democracy to total democracy. And nobody is at the total democracy end. People are on this continuum. Every society has its own genius. And there is something called the degree of democratization. Some societies are high, some are low. So we are also somewhere on that continuum.